Welcome to the Business SOS podcast. This is Rich Sierra. I am the president of Florida Small Business Legal Center here located in Boca Raton, Florida. This is episode 80 of Business SOS. I'm very excited and very proud that we have done 80 episodes and we'll continue moving forward to episode 100. I'm planning to have a celebration for that milestone since it's a big accomplishment to have your 100 episode. So today we're going to be talking, before I start, I want to basically give you an update on the Corporate Compliance Act, Transparency Act, that the FinCEN required, you were required as a corporate owner to file by January 1st. On December 3rd, there was a nationwide ban on enforcement by a U.S. District Court in Texas. So right now, that there's a nationwide ban enforcement that companies are now required to file the business ownership information, the BOI report. But right now, we're still monitoring the situation. If there's any more updates, we'll certainly let you know. You're welcome to check out the FinCEN website and find out what are you required to do. But right now, there's a nationwide ban on enforcement by a U.S. District Court in Texas. So we'll keep you posted on that as we move along, as we get new developments. So for today, I want to talk about my book, a chapter in my book, actually. As you know, I'm the author of Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. And you can get it in local bookstore by asking for it. So I'm going to first read your review that I saw, that I read, that I got recently, and I'd like to share it with you. And that was I'm very proud of this review, and I thought I'll share it with you. Let me find it for a minute. Okay. This is by Derek Wellington Johnson. He's actually an author of a book. He's going to be a future guest in our show, and I sent him the book just to review it, and we exchanged books. And he wrote this review, which is very nice of him. And I'm going to read it for you. It says, "Business SOS is the way I wish most books were written, packed with real-world, actionable information and zero fluff. I'm not exaggerating when I say the value of this book is well over $4,000 in safe fees to an attorney. Each chapter is the equivalent of sitting with a business attorney for 1 hour. If a good business attorney charges $500 an hour, well, you get the point. This is a must-have book in every business owner's and aspiring business owner's library." Thank you, Derek, for that very kind review. So today I'm going to talk about mistake number 8. Initiating or staying in a business lawsuit on the basis of principle. As you know, I'm a business attorney. I've been doing this now for about 20 years, and I've seen thousands of cases. Cases that most of them settle, but many of them actually go to litigation. And in fact, many of them that go to litigation are settling before you actually make it to trial for a number of reasons. And primarily the reason might be cost. And as I mentioned to you in prior episodes, and I gave you kind of a breakdown of what a lawsuit will look like and what will be the expenses of that lawsuit, you can tell that it's a very expensive proposition. And the analogy that I can give you is once you go to a toll road, wherever you live, like here we live in South Florida, so we have the Turnpike, we have 95, and sometimes I pay $1 or 50 cents every time we go. But think about if you're going to this same toll road and every time you go, you have to pay $1,000 every single time. And sometimes the work that you have to take a detour because somebody else, maybe the road was closed, and then you end up paying another $1,000. So you get the point in terms of the analogy that litigation being an adversarial process creates work that sometimes is created, many times created by the other side. And by doing so, the attorney has to react to that work, to that request, which create expenses for you. And I'm just making more of a simple example, and I can go into more detail at a later time on a different episode to talk specifically. And actually, maybe a topic that I'll do is the anatomy of a litigation case, anatomy of a trial, and kind of go and break it down in more detail for you. But I want to talk today specifically about staying in a business lawsuit or any lawsuit in the basis of principle. I've heard the phrase before as I talk to clients. I said, I'd rather pay you than pay him or her. If I had a nickel for every time somebody tells me that, I'll be doing very well. Okay, but the reality is just not, it's not feasible, it is not realistic, it's not a good reason to stay in a lawsuit because it's a principle thing that you want to prove. At the end of the day, business losses are about money. Either somebody's trying to get money from you or you're trying to get money from the other person or the other company. Or in some cases, it might be some type of injunction, you're trying to protect something, but for the most part, they're about money, and they stem from a breach of contract case. That's really the majority of business losses that I see. And I'll give you just a short anecdote. A few years ago, I had a case which somebody sold a piece of equipment without authorization, and then we ended up equipment was worth like $20,000. So we ended up suing the individual who took the equipment after it was told that equipment is not his and he was not authorized to receive the equipment, to buy the equipment, and then a lawsuit ensued. And told my client, listen, this is going to cost more than $20,000 of the lawsuit to actually collect. And so long story short, the client wanted to insist to stay in this lawsuit because of the principle and because this particular piece of equipment was so valuable to him. And soon we try to pursue different approaches, letters, trying to initiate litigation to settle the case. As costs continue to increase on the eve of trial, which basically we had a trial scheduled just like 4 days before, we started taking depositions and came to realize that, some of the facts that were provided to us were not exactly the same. And it really changed the whole equation. And the client had to basically drop the case because going to trial would have been very, very risky. And in terms of paying attorney's fees to the other side. And the client could have just said, I cut my losses and I move on. And sometimes that's a very difficult decision to do. But sometimes a bad decision is better than no decision, or continuing hemorrhaging legal fees is just more and more difficult later on. So I just, one of the many examples I can give you, but you get the point. So reasons why it is not a good idea to initiate or stay in a lawsuit on the basis of principle. I already mentioned number one, lawsuits are expensive. Okay, whether you are initiating a lawsuit or you're the recipient of a lawsuit, the advice that I usually give people is try to get out of it as soon as you can. It's just not going to get better with time. It's not like wine. It's not going to get better. Okay, so you want to get this done as soon and as efficiently as possible, to the extent that you can. Business lawsuits are not about principle. I just mentioned that. It's number two. Okay, it's about money, or you're trying to prevent somebody from doing something, or you're trying to recover something that is yours, but it's not about principle. It should never be. Lawsuits take a long time to decide. Here in Florida, we're trying to, when we initiate a lawsuit, we get a case management order from the judge, and the cases get resolved within 12 to 18 months. That's what their objective is. Sometimes it might take a little longer, but you're looking at a 12-month commitment at least, or 18-month commitments during the litigation. So let's say to talk about financial strain, but also you're talking about emotional strain that you will experience by being involved in this lawsuit. So you got to keep that in perspective as well, that it's not going to be, I'm going to file a lawsuit and they're going to settle. And I get that all the time. Said, just let's go ahead and file the lawsuit. Don't worry. Once they file a lawsuit, they're going to get scared and they're going to settle with us. Sometimes it does happen. Sometimes it does not. And I make them clear, listen, that may not be the case. That might not be the case that somebody receives a lawsuit, they're just going to go ahead and either not respond and get a default or go ahead and settle immediately. Because the moment they get an attorney on the other side and they're entitled to, that lawsuit is going to be defended, which is going to increase litigation costs. So Those are the things that I want to make sure that you're aware of. Another point that I want to make, I guess this will be number 4. Even when you're right, a lawsuit can devastate you financially. And I'm going to repeat this one again because it's important. Even when you are right, a lawsuit can devastate you financially. Now, I had a case several years ago within 2 partners that there was a buy-sell agreement. My client sold purchased the shares from the other partner. The partner felt that he was entitled to some distributions, and this battle took a number of years. It took a number of years, and my client was right. My client had all the defenses. We won some good motions. Ended up going to the appellate court, got reversed. The case continued, and even though the client was right, the client had to eventually go to bankruptcy court to get protection because they didn't have the financial resources to continue the litigation even when he had a good case. So you have to be careful understanding that even when you're right and you have a great case, this can devastate you financially. And there's no such thing as a slam dunk case, especially in business litigation and contract law. There are a lot of nuances, a lot of exceptions. There's a lot of details that go along the way. You're talking about human beings communicating and trying to make sense of what the agreement was, what the parties intended to do. So it's not very seldom you have a slam dunk case, at least in the context of business litigation, which is what I do. So another question that before you file a lawsuit, I have in my book, Business SOS, questions that I think you should ask yourself before considering a lawsuit. And I want to go over some of them. And I think the first question that you need to ask is, why am I suing? It's a simple question, but you need to ask, why am I suing and what am I intended to get from this? If it's money, and sometimes, yes, there's a reason to sue. I'm not saying that all the lawsuits should never be filed. I file a number of lawsuits every month. Okay, but there has to be an analysis of why a lawsuit has to be filed. I'll give you an example of a lawsuit has to be filed. You're owed a significant amount of money and that you did the work. And significant is relative to your situation. So I don't want to put you should sue because it's at least X number of dollars, because every situation is different. But at the same time, sometimes if you provided the work, you might want to, a lawsuit when all the other remedies have been exhausted, like sending demand letters, then lawsuit might be the only remedy that you have. So that's an example. Somebody stole trade secrets from your company. You might have to file a lawsuit to protect the trade secrets. Someone violating your trademark. After a demand letter, cease and desist letter, the person continues infringing your trademark. You might have to sue to protect your trademark. And there are many other examples as well. Somebody is putting defamatory statements, libelous statements on social media about your business, about you individually. You might have to sue to stop that. So there are a number of examples of why lawsuits are necessary. But at the same time, there are examples of why they're not. So I just want to make you that point. What do I want to gain from the lawsuit? It's another point that I like to make, that I like to ask. What are you actually trying to gain? Is it money? Is it protection? Is it property? So you need to ask that question as well. Very important question. What is this going to cost me? The cost of the lawsuit varies. And in some cases, the cost of the lawsuit can or will exceed the remedy you're seeking. And I'll give you an example just for the sake of giving you some numbers. Here in Florida, if you have anything up to $8,000, you have something called small claims, that we have small claims court. So you can go ahead and Oh, yes, the phone keeps ringing. The Yeah, small claims court. So that's something you don't need an attorney for. It's more streamlined, and in some cases you can do that yourself without an attorney. In fact, in Florida, even if you're a corporation, you can pursue small claims without an attorney. Anything above that, a corporation or legal entity will need an attorney. So you have, say, a $15,000 claim. So, and it's a breach of contract claim. What happens here is that the work that we have to do for a $15,000 claim is the same work that we have to do for $1 million claim in reference to procedures, in reference to motions, practice, in reference to rules of court, in reference to trial preparation. It's exactly the same. Of course, it can vary based on the number of witnesses, based on the number of documents, but the rules don't change for us in reference to the work, what is required of us to do the work with respect to the court. So that is something that a calculation has to be made. It's a good question to ask your attorney. You're asking, listen, what is going to cost me to start it? Well, it will cost me to get it through at least an early mediation. And if this goes over with a trial, what do you estimate? Because nobody can give you an exact number because remember, the other side, the opposing side creates work for you, for your attorney. Do you have an estimate or an idea what this will cost me all the way to trial? In our case, we do a litigation budget worksheet, and I'll give you the very worst case scenario, what it will cost. So you know it up front. Many times we get it settled beforehand, but at least there are no surprises along the way. It's important to know that. This is part of the calculation. So far, you have not filed a lawsuit. How long will this take? I mentioned earlier, could take between 12, 18, or 24 months. If it's a complex case, it could take up to 2 years. More time, it'll be more money, inevitably. How much am I willing to lose? So that's the risk management analysis you will have to make, the cost-benefit analysis you will have to make, depending how much it will cost. What are you willing to lose? If you're looking for, you have a $20,000 potential claim, and if everything goes perfect, you get your $20,000 judgment. And you won your case. But you also pay legal expenses. So what are the legal expenses are going to increase in reference to the potential amount that you'll actually receive? And how much you're willing to settle for is a decision that you have to make. And an example of that is, say, you go into a mediation, for example, you have a $20,000 claim, but they offer you 10. You say, no, I don't want to take anything less than 15. Fair. That's your decision how you want to make that calculation, but then you're looking at a $5,000 difference in reference to having a check written to you within a week and moving on with your life and not having this, litigation stress with you for a number of months, as opposed to getting $10,000, cutting your losses and moving on. That's a decision that is made every day by business owners as they're involved in lawsuits. Do I take this amount and move on? Or do I go ahead and continue? And that's where the principle comes in. It's a matter of principle. I have a situation, people stay in the lawsuit, even though they were offered not a perfect settlement. There's no such thing as perfect settlement. But they're offered something that, listen, it is money. You have something here. You can cut your legal expenses today and move on. Sometimes people take it, sometimes they don't. It varies. But that's where the emotional decision comes into play about, why do I want to stay in this lawsuit? It's a principle. I just want to solve this problem, make it a learning experience, and move on. And this goes into another question that I have here that I asked the question, what is the cost of doing nothing? That's a decision as well. What if you decide, if I do nothing with respect to the ones, for example, if you're suing, you have a $20,000 loss, and you said, okay, what if I do nothing with it? I lost $20,000. The reality is, if by the time that you are getting an attorney to try to collect the money that is owed to you, you lost that money because you don't have it. You deserve it, but you don't have it, so it's a loss. What are you willing to lose? Now, it's very different to say $20,000 versus in some cases that I have clients that are owed, up to $1 million. So that's a different calculation altogether, and how to pursue it based on that. What are you willing to lose? And that's an individual decision. I'm not telling you how to make that decision. I'm telling you, I want you to ask those questions. So far, you have not filed a lawsuit. The worst can happen here is that you make this analysis and say, you know what? It's not worth it. All you did was spend a few minutes, maybe an hour, going through some of these questions. Didn't cost you anything. One last question that I like to ask is, is there anything else I would rather use the money for? And that's very important. So you have, say it's going to cost you $10,000 to initiate the lawsuit and take it to a certain point. You're trying to collect, say, $20,000, $30,000. Okay. And there's no guarantees that you're going to win. Nobody can guarantee you that. You can have the strongest case possible, but nobody can guarantee you that you will win the case. So a question is, do I have $10,000 to spend? Do I rather spend it in this lawsuit to try to collect another 20? Or do I do something else with it? You have different priorities. So that's a decision you have to make, whether it's going on vacation, whether it's medical bills, whether it's another. It's completely your choice to do that. But it's also a question to be asked. Is there anything else I would rather use the money for? So I want to talk before I close, 10 more minutes or so. I want to talk about an alternative dispute resolution option, which I am a big proponent of. And I think at some point I'm going to bring somebody to talk about mediation and that practices mediation. But I've done many of them in my practice in 20 years. At least a few hundred of them, if not more. The mediation is an alternative dispute resolution. It is confidential, and it is really a great option to resolve business disputes before they escalate. As I mentioned before, when people file lawsuits, it's primarily for two reasons. They're ignored when they send a letter and there's just no communication with the party that they're seeking to get there's a controversy with. They're pissed. People are angry. They want to go ahead and say, you know what, screw it, I'm filing the lawsuit. Okay, that's the two reasons. Primary reasons that I see people filing lawsuits for. So mediation is a great alternative because number one is that you hire a neutral party, has nothing to do with the case. It's a certified mediator who practices in trying to be in a neutral, and the objective is to utilize that individual to come up with creative ideas and how to settle this case in a confidential manner. And in Florida, pretty much all cases go to mediation at the beginning or they go at the end. I like to have mediations at the beginning for two reasons. Number one, it saves the clients a tremendous amount of money when you go to mediation first. Yeah, you don't have the discovery, you don't have the depositions. You only have the information that you have. Okay, but there's a dispute. And sometimes by getting the parties together now we do them via Zoom, in a Zoom conference, with a mediator, sometimes in person as well, it may focus the next 4 hours of that time in trying to resolve the problem and having a conversation that maybe it never took place. By having professionals there trying to solve the problem, your thinking changes from litigating to solving the problem. So I'm a big proponent of that early mediation. There are no guarantees that mediation is going to be successful at the end. But there's an opportunity. It's an off-ramp from preventing the problem from escalating further. So when you have that mediation, it's a big proponent. It's also the cost of the mediation is less than litigating. Mediator might cost between $500-$600 an hour. Usually the parties split down the middle, plus you have your attorney's fees. Whatever time you spend in mediation is well worth it. So some of the benefits of mediation that I'll share with you. Um, and this is basically called the 8 C's. It's actually in my book, Business SOS. And I learned this from a mediator. Actually, was a federal magistrate doing a mediation a few years ago, and I really liked it. So I went and wrote him down and copied him, and I said I want to share this with in my book. And one of them is client control. You as the client, you have complete control of this mediation. I mean, the mediator kind of presides over it and has control of where the parties go and where they sit or where they would Zoom conferences and the decorum of the mediation. But overall, if the case settles, it's because the parties made the decision to settle the case. It was not because the attorneys made you say to settle the case, not because the mediator forced you to settle the case. No, because you as the client, along with the opposing party, made a decision that you'd rather take this problem off the court, of the judge's hands, and take control of your problem. Because the reason we go to court is basically telling the judge, the parties cannot solve the problem among themselves. We need you to solve it for us. And believe me, the judge will solve it for you. You might not be happy with the results. The judge will make a decision. And when you go to court, there will be a winner, there will be a loser. There's nothing in between. Mediation, you make the decision whether this is going to get resolved on your terms, not on anybody else's terms. So I'm a big proponent of mediation because it saves you money, and it's also because it's effective. Cost control, I kind of touched upon that just a few minutes ago. Mediation it's less costly, less expensive than litigating. So you have an opportunity on that particular day to completely shut down your legal expenses, cut them off, and solve this problem. So you have that opportunity. It's no guarantee, but it's all about an opportunity. Okay, so you have cost control, but you can decide whether to continue or not, and you can control the cost in this case. Comfort. The mediation, although it's an informal process, but there's some rules that we have, but it's more comfortable than being in court. It's either going to be in an office, an attorney's office, in a conference room, and then you separate different caucuses, but it'll be more comfortable. You'll be with your attorney, or it'll be via Zoom. You might be in your office or be in the comfort of your own home. It's a more relaxed process, and you'll have the ability to think and try to think about solutions rather than being stressed out about what the witness is going to say, what the judge is going to say, and attorneys coming out with motions that you will not understand because you're not an attorney, and you feel that you don't have control of the case when you're in court, and most likely you're right. The judge has control of the case and the attorneys have control of the case. You're basically at the mercy of the attorneys, hoping that your attorney does what he's supposed to do, and the other guy makes mistakes, or the other attorney makes mistakes, or that the witness gives the testimony that you're expecting the witness to give to help your case, or that you actually testify that you don't stumble in your answers. There's just so many different factors along the way. Mediation, you have comfort, you're in control. Courtesy. That's number 5. The objective is to have courtesy, and it's a very respectful process to the mediation, civil process. It's not about name calling. It's not about, getting angry. It's about coming up with solutions. And the objective is to have courtesy among each other. You'll still have it in court the same way, but it's a very courteous and very relaxed and very friendly process. Even though we have differences, you have claims, the objective is to have a conversation in a courteous manner. This one I like a lot. It's number 6 is creativity. I'm a very creative person, and I love about mediation is that mediation gives you a blank canvas. You can come up in business litigation, you come up with different types of solutions and options to try to solve a problem. So there's creativity that goes into play in between the other attorney, between the mediator and the parties, and try to craft a solution that would satisfy the parties and that will get you to a closer resolution or a compromise that otherwise you will not have in court. In court, you'll have a verdict. Either you won the case or you get a judgment, or you lost the case and you have to pay money, or you get nothing. And then that judgment most likely will be appealed to a district court of appeal, and then you have another 2 more years of litigation. And I'll bring an attorney to talk about appeals at some point. That's a great subject, so I'll have an appellate attorney come in and talk to us. But the litigation continues after you win the case or lose the case, so it doesn't stop there. So creativity is very important, and I like mediators when they're creative and come up with solutions a little bit out of the box. The business owners are creative as well. And the reason they're business owners is because they want to pursue the businesses and they're creative in how they solve problems. So creativity is one of my favorite ones here. Another one here is confidentiality, number 7. The mediation is a confidential process. What happens at mediation stays at mediation. There's some exceptions, but we don't have to go over those now. But for the most part, whatever it says in mediation stays in mediation, and the mediator cannot be called to testify. You can make an admission of mediation that cannot be used in trial. Nobody can ask you, well, the mediation you said A, B, C, and D. They cannot ask you that question. In fact, the attorney can be sanctioned for trying to ask questions about the mediation. So the confidentiality process is important, or what I call the cone of silence, is to encourage people to talk and to share in order to solve the problem. So confidentiality is very important. Last but not least is number 8, compromise. When you have a good mediation, it's about the compromise. And in a compromise, each party is going to leave a little bit unhappy. If you're trying to collect money from the other side, if you settle the case, you most likely will get less than what you're expecting for. If you're the party who will be paying the money of the settlement, you will be paying more than you were expecting to pay. But it's a compromise. At the end of the day, you'll have closure. There's just one here, see that I miss here, but I'm adding it anyway. It's my show. I can do it. So you have closure. So closure is important to you. Unless you're an attorney who does this for a living, you're not in the business being involved in legal disputes. So the sooner you have closure with this matter, even if it costs you a little bit of money, you're better off than continuing perpetuating that trauma or that drama of the litigation. So closure is very important. One that I missed, I was looking at my notes, is commitment. I think I've already 10 C's. It's supposed to be 8, but I'm over 10 or 9. So commitment. It is important when you do a mediation is commit to the process. Nobody's asking you to commit to a settlement that day. But what mediators will ask you is to go with an open mind. Listen. Speak. But most important, listen to the other side. But also commit to the process and allow the mediator to do his or her job and ask questions, answer, and basically sometimes put you a little bit uncomfortable because he's trying to do that with both. But commit to the process and trying to solve the problem and get your mindset to thinking, I want to see if I can get this done today. Because when your mind changes to think about solving the problem, 9 out of 10 times, the case gets settled. So that's very important. So committing to the process is very important. As I mentioned before, I want to close with this. To the extent that you can, try to avoid a lawsuit. Try to avoid litigation. Try to avoid it. It's very costly. It's expensive. Sometimes unnecessary. And if you're in it, try to be as effective as you can. And that's why the conversations you and your attorney are very important, and how this lawsuit will be utilized strategically to meet your objectives. There has to be an end in mind where you're filing a lawsuit, or it also has to be an end in mind where you're trying to defend a lawsuit. But that goes into strategy and tactics that you'll speak with your attorney. It's a whole different conversation. The point today here is that a lawsuit based on principle is just not a good idea. That's my opinion, simply for the reasons that I just mentioned before. It's very expensive, costly, stressful, to the extent that you can avoid it, and you're going to be better off that way. If you don't have any losses, you're actually in a better shape. But if you're in it, or you're threatened with one, consider, obviously speak with your attorney give you advice on how to proceed. This is good for today. I like to, close. If you need to reach me, you have any questions about any topics that I've covered before, you can email me at rich@richsierra.com. Again, it's rich@richsierra.com. If you're interested in learning about my law firm, the legal services that we provide, and we've been doing this now for 20 years, my website is floridasmallbusinesslegalcenter.com. We're at Facebook at FSB Legal. Again, FSB Legal. If you'd like to watch the video of this podcast, we're on YouTube at youtube.com/@RichardSierra. We're on Instagram at FSB Legal. And if you want to give us a call, the number is 866-842-5202. If you like, also Business SOS, 8 common legal mistakes business owners make and how to avoid them. Remember, it's available on Amazon, Barnes & Noble. You can ask for it at your local bookstores as well. Very proud of this book, and many people have read it and get great feedback from it. If you like it, please give us a review as well on Amazon. I think it'll be helpful, and share it with other business owners. Likewise, if you like this podcast, I appreciate if you give us a 5-star review, write something about your thoughts and the review as well. Helps the algorithm share with other business owners as well. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. And remember that my goal is to help you succeed.